Okay, friends, today we get to talk about mergers and acquisitions.
Oh.
Mergers and acquisitions, M&A work. It's a fun acronym. Doesn't always mean what you think it means. When we're talking about a purchase agreement, when you're buying a business, when you're the buyer, there's three things that you really need to focus on to make sure that you get to actually purchase what's important to you. Number one is make sure that the key personnel are under restrictive covenants. We talked about this a little bit before in another video. It's important when you're buying a business, and a little horror story here. Earlier we had a client buy a business. She did not get restrictive covenants. Those are non-competes, non-solicitations, non-disclosures, non-disparagements even. And everybody at this shop just carte blanche left after she came in and owned the business and started to, run everything. They didn't really like the buyer, and they decided to set up a competing business literally right down the street. And so everything she paid for the company was just gone. It's sad. That's what happens if you don't have non-competes, restrictive covenants, and all of that in place. Number two that we need to talk about is make sure that the seller owns the trademark. If the seller does not own the trademark and is not selling you the trademark, they can't really sell you the trademark. The trademark requires that you have at least a state trademark filing. Ideally, they'd have a USPTO federal trademark filing, though, because that's way better. That's way more strong. They can use it across the entire United States and even the U.S. territories. They can own their brand. The third thing is that they have an assumption of the liabilities before the sale. So this is a big thing in the purchase agreement itself. Okay, it's some contractual language. Basically, it just says, as you would expect, anything that they haven't disclosed to you, any liabilities that were generated from stuff that went on before the date of the sale when you buy it, is on them, right? So it's different from buying a car where there's, no warranties or whatever. We had a client come to us many years after this happened, but they had purchased a company and they later found out that there was a lease that was not paid on for something like 8 months, and a bunch of creditors came knocking on their door, and they, thought that the company owed them money, and we had to sort of settle it and work it all out. So make sure that the seller assumes the liabilities for all of the stuff that took place before the date of closing. The rest is just the basic stuff, doing your due diligence, making sure you're focusing on all of that. You might also want to check out their partnership agreement to make sure that they have the authority to actually sell it, because otherwise they just might argue that, the person that sold it to you didn't actually own it in the first place. That's about it when we're talking about buying a business. There's a bunch of, important things. Mainly, you're just looking at the employment contracts to make sure that you can keep those key employees and the trademark. The third thing is just the purchase agreement itself, which we're happy to help with. I'm Jonathan Sparks with Sparks Law. Smart business decisions start with Sparks.